Good afternoon, Madam Chair and members of the committee. My name is Renee Carlson. I serve as General Counsel for True North Legal. I'm also a former high school athlete, a coach's daughter, and a mother of female athletes in Minnesota. Girls' sports are a remarkable American success story in Minnesota and across the country. Even as the Supreme Court has strengthened protections for women, this cornerstone has remained, quote, physical differences between men and women are enduring, whereas equal opportunities for girls mean separate opportunities reserved just for them. Nearly 50 years ago, Congress enacted Title IX, a federal law historically recognized for breaking down barriers to women and girls. Minnesota followed, enacting what a Minnesota District Court deemed the counterpart to Title IX by passing its own protections for women and girls in Minnesota Statute 121A.04, formerly 126.21, a trailblazing law in which the spirit and intent of the law has always been protecting female opportunities through specific teams designated for females by explicitly requiring sports teams to, quote, be restricted to members of a sex whose overall athletic opportunities have previously been limited. At one point in time, the Minnesota State High School League agreed. In 1993, the league released its Gender Equity in Athletics Guidance, a 174-page manual referencing the statutory scheme, instructing Minnesota schools about, quote, the importance to our country's future to eliminate the barriers and ensure that females have the opportunity to reach their full potential as citizens in our democratic society, end quote. But nearly 10 years ago, in blatant disregard for girls and the law, the Minnesota State High School League swiftly adopted policies that erase girls from girls' sports by allowing males, and at times men, to take girls' opportunities while putting their physical safety at risk and robbing her of her dignity. While many states and federal government are decidedly protecting girls' sports, Minnesota girls must fight for their athletic existence because Minnesota laws that were designed to protect them are now being used against them. This, despite recently issued executive order keeping men out of women's sports, making clear the federal government has no tolerance for violations of civil rights, including, quote, dangerous and unfair practices of men in girls' sports, and legal guidance by federal courts across the country, including in Tennessee versus Cardona, the case that vacated the Biden administration's interpretation of Title IX, which held, quote, there are two sexes, male and female. Redefining sex to include gender identity contravenes the plain text of Title IX, which sought to level the playing field between men and women. Expanding the definition of discrimination would eviscerate the statute and render it largely meaningless, end quote. And still, the Minnesota State High School League has made no indication of intent to change its policy, allowing males to play on girls' teams, which has made it the subject of one of two federal investigations by the Department of Education's Office of Civil Rights. To be sure, any legislation or legal interpretation seeking to undermine the protections afforded to girls make a mockery of their achievements and gains over the last few decades. Advocating for females against aggressive attempts to push them out of their sports is always the right thing to do. Our daughters deserve better than what they're getting from Minnesota school districts, athletic associations, and even the state government. For those who disagree, I have a question. Which of the incredibly talented female athletes on any Minnesota high school team deserves to be displaced by a male competitor? The answer is none of them. House File 12 is a necessary step forward in reaffirming and strengthening the protections female athletes should enjoy under state and federal law. That's the best way to give girls the opportunity